Good afternoon to those of you on the East Coast. Good morning to those of you on the West Coast. Thank you for registering and joining us for today's webinar, where we intend to review draft legislation on the Internal Revenue Service's General Welfare Doctrine. Today's webinar is hosted by the organizations you see listed on your screen: the National Congress of American Indians, the United South and Eastern Tribes, the Affiliated Tribes of Northwest Indians, the California Association of Tribal Governments, the Midwest Alliance of Sovereign Tribes, the United Indian Nations of Oklahoma, Kansas, and Texas, and Native American Finance Officers Association. Before we get started today, we'd like to go over some general housekeeping items, then give a brief overview of today's discussion. So if you look at your screen, you will see a question box in the upper right-hand corner of your screen. You can expand and collapse this box to improve visibility of the presentation. You also find a dial-in number and passcode for today's discussion. Next, we wanted to note that there are two ways that you can ask a question today. One, you can raise your hand. To do this, you can click on the hand icon. We will unmute your line and you can ask your question. And two, you can type your question in the question box. The questions will be answered in the order they are received. So here's the roadmap for today's discussion. We will start with a welcome and opening statement from Chief Malerba from the Mohican Tribe. And then next we'll get a brief overview of legislative landscape for tribal tax policy and a background context for today's draft review. And that will be given by Arlene Martin from Spirit Rock Consulting. After that, we'll move to a review of the draft legislation, and that will be led by John Dossett, General Counsel for the National Congress of American Indians, and Wendy Pearson, tax attorney at Pearson Law. And then we'll follow with the question and answer period where we will answer your questions. So now I will turn it over to Chief Malerba to begin today's discussion. Thank you.
Thank you, Derek, and good afternoon to everyone. I'd like to welcome you all to today's webinar, and I truly appreciate the ongoing participation of the tribal leaders on this very important issue. There are so many tax issues being discussed and addressed in Indian country, and I do believe that really now is our time to address the things that are most important to tribal leadership and to our communities. So during the discussion on the general welfare exemption, we've heard from leaders throughout Indian country regarding the three overriding concerns. First, tribal sovereignty needs to be respected. Each tribe has a very different legislative process. Some are written, some are oral by tradition, and they will develop their programs for their citizens accordingly. Secondly, there needs to be flexibility in developing programs to address the concerns of their citizens. Each tribe has the sovereign right to develop their programs to address their community needs in the best way that they see fit. Lastly, all the governmental programs that we offer our people replace or supplement the trust and treaty responsibility of the federal government, which, as we all know, has been lacking. The general welfare exemption efforts have been the topic of much discussion in Indian country, and there are two initiatives that are ongoing. The first are the administrative efforts to address Notice 2012-75, which was the topic of the last webinar. It truly is incumbent upon every tribal nation to submit comments on this guidance, which are due June 3rd. As we all know, there are concerns with the guidance, and we should be clear about what is acceptable to tribes and what is not. And the other issue with guidance alone is that it's changeable and not protected by law. Indian country has been very successful in getting movement from the IRS on these issues, given where our starting point was. But as we all know, there are still shortcomings with the guidance, such as ensuring that deference is given to the tribe, and whether we should even attempt to define what's lavish and extravagant, and I would use those as two examples. More importantly, I think in order to ensure that our gains are protected, we truly need to apply pressure to Congress to take this progress even further by our legislative efforts. We should insist on governmental fairness with regard to all tax reform. We need reliable and effective federal tax policy to firmly support tribal governance, while we protect the ability of tribes to generate and retain the full use of tribal revenues. All tribes continue to ask for a moratorium on IRS audits. All tribes continue to insist on training and education for field agents, and we are all requesting a tribal advisory committee within the Department of Treasury. There is additionally a legislative effort that we are going to discuss today to codify the general welfare exemptions in a way that respects tribal sovereignty. Today's webinar really is intended to begin the discussion of this very early draft legislation. It's extremely important that the tribal leaders provide guidance on this draft legislation to ensure that we underscore the government-to-government relationship that exists and that we expect this relationship to be honored. One of the issues we need to focus on is that the legislation should be as broad as possible to allow for tribal culture and tradition to be expressed, not only in our process for program development, but also in our determination of what programs are needed for our communities. So I encourage everyone to think about what language accomplishes that goal so that the legislative effort is a strong and successful one. We all know that Indian country is most effective when it speaks with a united voice. The challenge for all tribal leaders is to, one, not narrowly define the language where it becomes too restrictive, and two, to be broad enough where it is flexible and interpreted in our favor, and three, to come to agreement on language so that non-Indian interests do not create the language for us, which we all know is a huge risk. So what's very important to recognize and to think about is the fact that there are many, many tax issues, such as tribal bond offerings, kitty tax, and other issues to engage on and discuss. And this really is just one issue that we are working on. And so on that note, I'm going to turn the webinar over to Maureen Martin for a discussion on other tax initiatives. So thank you for joining us, and I hope that this is a very interactive webinar.
Thanks, Chief Malerba. I'm Maureen Martin. I work with Spirit Rock Consulting, and my task today is to kind of give you a background of what's going on in Congress on the legislative efforts to marry our tribal provisions with overall tax reform. And I just wanted to kind of give you a big picture idea of what's happening with tax reform and then talk a little bit about the specifics of tribal proposals that are hopefully moving through the House and the Senate. In terms of the big picture, it's clear that tax reform is a big priority for both the House and the Senate, but in particularly for the House. They've identified it as their top priority, with the House Republicans giving it the bill number of H.R. 1, and so it's clear that's something that they really want to move forward. We expect to see a big push on tax reform beginning as early as late summer here, where there might be some discussions on raising the debt ceiling and maybe attaching tax reform to those efforts. But we also expect these efforts to move forward if tax reform doesn't go through the end of this Congress, which would be late next year. Even if tax reform doesn't move forward in this Congress, I think that everyone feels the conventional wisdom is that whatever bill is going to form the basis for tax reform in the House is going to be a vehicle that will form the basis of future proposals for years to come. And so our ability to get provisions in one of those base bills is, will be a huge win for us, because we'll be in the discussion from the get-go moving forward. As Chief Malerba had indicated, there are a lot of different tribal tax issues that have come to the forefront and come into our consciousness over the last 2 years. And those include the general welfare doctrine, which seems by far to be one of the top priorities of Indian country, the tax-exempt bond provisions, and the issue of the essential governmental function. That's the same issue that's part of the tribal pension plan fairness issue. And then a number of what we're terming technical fixes, but are really fairness issues where tribes should be included in provisions that give benefits to other governments. And not last or not least is the economic development provisions, like accelerated depreciation, the employment tax credit, new market tax credits. So, and keeping in mind that tribes have been meeting on all of these issues with representatives in both the House and the Senate, it seems that because we've been, I think, maybe most vocal on the general welfare doctrine, we were able to convince someone to put together draft legislation. In terms of what's going on specifically in the House and the Senate and how we expect things to move forward, I think the conventional wisdom in Washington is that the House will probably develop legislation and consider it first and send it to the Senate, where the Senate will consider it and then make changes and probably send it back. So with that in mind, I think that a lot of tribes have been focusing their efforts on the House side. I think people are still meeting with the Senate. They're still talking to the Senate, but really concentrating efforts on the House side to try to get provisions in the base bill that's being developed at the Ways and Means Committee, but also looking for sponsors of individual tribal legislation that could be put into the House package at some point. So one of the people that tribes have been talking to on the Ways and Means Committee is Devin Nunez, and he is a senior member of the committee. He's a member from California, the 22nd District, which is near Fresno, for those of you who are familiar with California. And he's been on Ways and Means since he was elected to the House, I want to say in 2004. And he's actually been supportive on tribal tax issues ever since he's been in the House. He's in the past circulated, well, he's actually co-sponsored legislation on tax-exempt bonds and eliminating the essential governmental function on 2 occasions. He circulated the first draft of the Health Benefits Clarification Act, which was part of the Affordable Care Act, and co-sponsored the legislation which was ultimately introduced with Javier Becerra. And then 2 years ago, he circulated a discussion draft on cultural and religious benefits, kind of furthering the idea that was contained in the Tribal Health Benefits Clarification Act, and it was a part of our efforts on the general welfare doctrine bill. So he's been very supportive on tribal tax issues and tribal issues generally. And tribes have been talking to him about doing a base bill which could be rolled into tax reform. They've been talking to him for the last 2 years, and I think one of the things that he's done has been collecting information, and the top priority that he saw coming in from tribes was general welfare. And so he took the drafts that he was receiving from tribes and gave them to the House Legislative Council, who developed a draft bill, which is the subject of our discussion today. And talking to his office, what they've told me and other tribal advocates is that this is just a draft. It is not his solid position with regard to how he feels about general welfare. It is not an effort to roll back the IRS guidance. It is truly put out there because he saw a number of different proposals, and he wanted to try to get something that everybody could be working from and improving on. So what they would like to see from us is a red line version of what we think this bill should look like, using this as a basis for our comments. And they're definitely amenable to changes. I think that they would be very supportive of leaving the section that's bracketed on ceremonial activities in there and expanding upon it. We've heard that that they are amenable to changing the section on need. And so I think this presents a positive move for us forward, a big step forward, and it's something that we can work with, sending back to them what Indian country really feels this language should look like and what our needs are. So I hope I haven't talked too long, but at this point, I'll turn it over to John Dossett and Wendy Pearson.
Thanks very much, Irene. I think Derek, this is John Dossett with NCAI, and I think that Derek Bizzo, who does all of the work on the webinar for us, thank you, Derek, is going to bring up a copy of the language that we've been working on. And what you're going to see is Nunez's bill amended, and we didn't put it in red line strikeout. We thought that would be too confusing for a webinar. This is just, the Nunez bill with our changes to it, and we'll kind of talk through what the proposal will look like if it were enacted in this form. And this would be a draft that we would send back to Congressman Nunez to get his input on. But we wanted to share it with folks, just keep everybody informed about what's going on with the legislative proposal. So let's walk through the draft. It's not very long. Starting at the beginning, Section A. If you scroll down a little bit, this is Section 139E. It would add a new section to the code. And it says gross income does not include the value of any general welfare benefit. And then it goes on to define what a general welfare benefit is for an Indian general welfare benefit. It would include any payment made to or on behalf of an individual by an Indian tribe. And that's one of the changes we made. The earlier version just referred to tribal members, but we understand that tribes often provide services to folks who are parts of the community. Maybe they're spouses or descendants or otherwise may not be eligible for tribal membership, but they're still part of the tribal community that receives services. And that's fairly common among some tribes. So we expanded that terminology. And then if you go down into the guidelines, the program would be administered under specified guidelines developed by the tribe and does not discriminate in favor of members of the governing body of the tribe. Some of that language will look familiar from the IRS guidance. The benefits have to be available to any individual who meets the guidelines. They have to be for the promotion of the general welfare, including programs based on individual, family, or community need. We added the term community. When in the discussion with the IRS about this, one of the big concerns was that IRS was trying to define need as only an individual's need, and that could be means tested, that you could measure the person's income and see whether they needed assistance with education. And the response from tribes was that tribes are looking more after the needs of the entire community and provided services that benefits everyone. So consideration of community needs was included here. The benefits could not be lavish or extravagant, and they could not be compensation for services like payment to an employee. So that's the general idea of what an Indian general welfare benefit would be under this draft. If you go down a little bit more, the next language I wanted to point out that we thought was very good from the original draft was that the program shall not fail to be treated as an Indian tribal government program solely by reason of the program being established by tribal custom. And we thought this was really important because many tribes have they have programs and benefits that they've supplied for years or decades or even longer to tribal members, and that the tribe wouldn't necessarily have to create a new program. They could rely on their traditional customs. And with that, I think I'm going to turn the rest over to Wendy Pearson to talk about the presumption of need section. Wendy, I think she wrote out this part, and it kind of breaks down some specific programs that would be specifically included within the scope of general welfare. So Wendy, I'll turn it over to you.
Sure. And so, yes, we added this section, subsection C2, presumption of need, to the Nunez draft. And the thinking was that we were concerned about losing the ground that we had gained through the current IRS guidance where there are safe harbors for certain programs. And so we didn't want to lose that ground or leave it to chance that if the proposed bill were broad and didn't identify specific programs, it would leave it to chance that the IRS would not modify the current guidance or issue regulations that were more restrictive than what we currently have. So the idea here is to specify or include in the bill the programs that we already have in the safe harbor. And then the draft attempts to not only articulate the current guidance for the safe harbor programs, but also take into account some of the comments we've received to date from tribal leaders and communities about the guidance and how that needs to be changed. So this is an attempt to be all-encompassing, to propose that these programs will be specifically exempt. So, so it provides that presumption of need is established, or payments are presumed to meet an individual, family, and or community need for these types of programs. So the first one is the housing program, and it's a program that would relate to principal residences. here we kept the restriction on principal residences that you find in the IRS guidance, but took or eliminated the on or near reservation limitation, which was a concern for many tribes, because there's some situations where the principal residences will not be on or near the reservation, of course. So this would allow payments that assist payments for utilities, rent, mortgage, and acquisition down payments. Again, we added the down payment assistance from the comments that were received on the IRS guidance. And then generally to enhance habitability of housing. And the idea here is that this is a somewhat broad prescription that would allow housing repairs, rehabilitation, modifying housing to code, and so on and so forth. So it's a little bit it's intended to be more expansive than the IRS guidance as it's currently drafted. So then moving on to educational programs, this would exempt payments for transportation for students to and from school, for tutors, and for payments for tutors, and payments for supplies for use in their studies. This parallels the current guidance from the IRS, but also it does not mention limitation, or what might have been misconstrued as a limitation to apply only to post-secondary schooling. So this would apply to any level of schooling, K through 12 and post-secondary. Secondly, to provide tuition for students, including room and board, to attend accredited college, vocational education, technical education, adult education, continuing education, and alternative education. Again, here we're just listing consistent with the guidance, all of the types of education for which payments of tuition and room and board would qualify for exemption. Payments for job placement and training, including expenses for tutoring, interviewing, and then clothing allowances. Again, trying to keep the language a little bit broader than how it appears in the IRS guidance to address some of the comments that were received about, how much, what type of clothing, and how much for job placement and training and that sort of thing. So again, keeping it broad enough to allow some flexibility for the tribes to tailor their programs to the particular needs of the community. And then finally, to provide for daycare to enable students to pursue their studies. So this was also an additional provision based on the comments. So then the next program would be elder and disabled programs for individuals who have attained to age 55 or who are disabled. Again, we set this out in a way that's a little bit broader than what you'll find in the IRS guidance. So, for instance, payments to provide meals and food and in-home assistance to prepare meals. The IRS guidance had addressed meals only, and there were many comments about providing assistance with just food and groceries and that sort of thing. So the idea here is that this is broad enough to cover a program that would pay for groceries and allow for in-home preparation of meals. Transportation assistance, not limiting it to quote-unquote local transportation and not limiting it to the type of transportation, but just transportation assistance in whatever means and for whatever reason. Home care, daycare, and then to provide improvement to adapt housing to special needs. And you'll find that the IRS guidance had limited some of the elder programs to those which were quote-unquote offered by the tribe. So we've removed that limitation from the current proposal. And then we have the cultural and religious programs. These would be programs which provide transportation, food, and lodging to attend cultural, social, or community activities such as powwows, ceremonies, and traditional dances. Again, this is a little bit broader than the IRS guidance, not limiting the type of transportation, trying to keep the sort of the reimbursement or the payment for travel expenses fairly broad. The second one would be to provide transportation, food, and lodging to visit reservations and sites of cultural and historic significance. This tracks the IRS guidance fairly closely. Pay or reimburse costs of receiving instruction about an Indian tribe's culture, history, and tradition. And then pay or reimburse funeral and burial expenses and related bereavement events. So you'll find that this is pretty close to the IRS guidance, but is a little bit broader and intended to encompass practices that weren't articulated in the guidance, say around bereavement events or particular memorials or ceremonies and religious programs and that sort of thing. And then finally we have the emergency relief, sort of the catch-all that has emergency relief and other programs. And this would then exempt payments for transportation allowances to public facilities, again, not limiting the type of transportation. Payments for transportation and temporary housing while tribal member, spouse, and dependents are receiving medical care away from home. This is pretty consistent with the current IRS guidance provision. And then assistance payments in exigent or emergency circumstances. So instead of articulating all of the specific type of emergency or exigent circumstances or the examples that the IRS gave on what type of transportation would or assistance payments would be allowed, like bus fare, or limiting the emergency situation to being stranded off the Indian reservation. This is just attempting to make that allowance a little bit more broader and again give tribal governments more flexibility in how they would tailor these special emergency assistance type of programs. So John, I'll give it back to you to cover ceremonial activities and deference.
Oh, sure. If you look at the ceremonial activities section, it says that any payment for participation in cultural or ceremonial activities shall not be treated as compensation for services. This is a bit broader than the IRS guidance, which referred only to nominal payments, and I think there were questions about what does nominal mean and would it be restrictive, so this doesn't use that terminology. And the next section is one that we added about deference, and this came up repeatedly in our conversations with the IRS, and I'm not sure that they ever really took to heart what tribal leaders were saying about how the IRS was substituting its own judgment for what were the community's needs, and that's really the tribal government's job to determine what the community needs are and to provide for them to the best of its abilities. And so this would, if enacted, right now this is just a draft, but the idea here is that the language of this statute would be construed with deference to the tribal government's decisions about the community needs. And to some degree, this is also an answer to questions about lavish and extravagant. I know that people have raised concerns that, what does it mean, lavish and extravagant? On one hand, that's a fairly well understood term within the IRS because it's a restriction on business expenses. And maybe, Wendy, you can talk about this, but I think the IRS is pretty used to dealing with what is and what is not a lavish business expense, and business people seem to stay at the Four Seasons all the time, so they have a fairly wide range of what they can do with business expenses. But on the other hand, we didn't want to we didn't want the IRS second guessing what's lavish and extravagant, so this idea of deference to the tribal government decisions would fill in there as well. Wendy, do you have any sort of illumination on what lavish and extravagant means when it comes to business expenses?
Yeah, the test is really based on the quote-unquote facts and circumstances of the situation. So there's not a bright line test. There's not, an amount that's specified. The IRS and the regulations they basically suggests that lavish and extravagant would be determined based on the context, based on the facts and circumstances. So here what we'd be saying is that deference would be given to the tribes in determining under the facts and circumstances the appropriate level of assistance or payment required, so that in that facts and circumstances test, the tribal government is going to be given the benefit of the doubt, and presumptively their determination of the amount required or necessary would be given deference.
Right. So perhaps for an example, many tribes provide transportation assistance to tribal members, maybe to go to attend college or something like that. But if the tribe was handing out Ferraris to every tribal member, they may not get, that might reach the point of lavish and extravagant. Let's go down a little bit as far as conforming amendments, which is really just the title of the legislation. The last section is one that may be worth some consideration. The effective date would be at the end of last year, so it would start at the beginning of this year, the tax year that we're currently in. And that's a little bit different than the IRS policy, which I think the IRS with their policy, they were willing to reach back a few years and say that they would give the new guidelines application to things that happen in several of the past years. I think it's going back 3 years. Is that right, Wendy?
Yes.
Yeah, so they were willing to go back 3 years. At least my thought was Congress is less likely to enact retroactive litigation that's on taxes. That's really something that there's kind of this thing against retroactive tax legislation. But they, the guidelines, the IRS guidelines, which are currently in effect, would cover past years, and so that there would seem to be some protection there. And then the no inference section says that nothing in this amendment shall be construed to create an inference, with regard to the application of the general welfare exclusion on anything that happened before the date of enactment. So that's, I suppose, some additional protection for whatever occurred in past tax years. And that's really it. I suppose at this point, well, I'll turn it back to Derek, and we're going to go to questions and comments on this proposal.
Yeah, thank you, John. Thank you, Wendy. And thank you, Irene and Chief Malerba as well. Just a bit of housekeeping. We are recording this presentation, and we will send out slides and a copy of the draft bill as well to everybody that's registered for this webinar. And you're encouraged to share this freely amongst your networks. One of the first questions we have is from Judy, and she wants to know, and I think Wendy covered this section, whether or not the education benefits section would extend to Head Start.
Well, it seems like it should be construed broadly enough to do that. I'm just looking at the language here to see if there's anything that would limit construing it that way, and I don't think it would. Yeah, I mean, I think that would be fine. I think that that the legislation that we're proposing as drafted would exempt that sort of the Head Start type benefits, unless there's a specific type of benefit that we've not identified here, something outside of tuition, room, and board, or supplies.
I have a question about daycare. Is that suppose the tribe provides daycare not only for for students, but for for working tribal members, so that they would they could go to their jobs because they have daycare. How would that be covered under this?
I don't think we have it covered under here, actually.
This is Lynn, and I think that that's one of the things we have to think about. I think all of the examples that we've used for the different programs are good, but do we want to have some mitigating language that says including but not limited to? Because there are going to be things that we haven't thought about in this legislation, and we want to make sure that we're not tying our hands. And I think daycare is the perfect example of that, because there are tribes that are trying to get their tribal citizens back to work, and in order to get them back to work, they are going to provide assistance with daycare. So that is a community need to have their citizens be productive, and one of the ways to support them through that is to provide daycare. So I just throw that out as a question. How detailed do we want to be in the list of services that or programs that we're going to talk about?
Right, and what we're talking about here is that, under subsection B, any program that meets those requirements there in 1 and 2 would qualify for the exemption. And then we're saying, but there's this class of programs where need will be presumed. So then you only have to meet the written guidelines type of, or the governmental program requirement under specified guidelines, and the non-discrimination requirement and the not lavish or extravagant requirement. So, I think that's a good point. There's what may be somewhat of a competing concern of having this be very flexible and very broad, where we wouldn't really identify specific programs for fear that we can't possibly list them all and we'll miss some. But on the other hand, we've already gained so much ground with the IRS notice that we don't want to lose that ground and leave it to chance that IRS will continue to interpret this new statutory provision as broadly. So.
Right, and I think that that's where the balance and the finesse for this legislation is going to come in.
Yeah, I think one of the things that I noticed in this general welfare discussion overall is that you have two things going on. One, you have the codification of the doctrine, which is broad, and then the other thing you have going on is the protection of certain programs. So you're seeking an exemption for certain types of programs. So I think sometimes the straddling the line between including aspects of both of those approaches is kind of the difficulty that we're discussing right now. We have a comment from John right now, and he says, the Nunez draft definition of Indian general welfare benefit is a positive step to broaden the guidance. Instead of including C2 specific programs as a first option, why not simply delete? And then he references the section that's based on individual or family need. If this doesn't succeed, including C2 could be a fallback position. Listing and defining programs limits the breadth of the possible programs and services. And now it was just a comment, but I was wondering what your thoughts were on that, Wendy and John, and maybe Irene and Chief Malerba as well.
It's tough to. I think Wendy kind of responded to it. I mean, the tough part, I think, is that tribes have already gained so much in the IRS notice that what is it? Notice 2012-75, and where the IRS listed out a very large number of programs that are just automatically exempted. You don't even have to demonstrate that they're exempted, except that they're written down somewhere. And that's really very good for the broad majority of concerns that tribes have had in this field. But on the other hand, the point is very well made that we're not going to think of everything. There may be types of programs that we aren't considering. There may be services that tribes will provide in the future that we can't even imagine right now. And how do we write it broadly enough to cover both of those? I think what we've been trying to do so far is to have it both ways, to have both a broad general statement that would cover an umbrella that would cover everything, and then under that to list some specific things to kind of take advantage of what the work that's already been done with the IRS guidance. I think maybe we just have to make sure that we express that clearly enough. Does that make any sense to you, Wendy?
Yeah, I think so. I would just be concerned that, administrations change, which we're witnessing right now at the IRS, and you know, a large part of the ground that we've gained so far in the general welfare exclusion has been by reason of, you know, our help at Treasury with Aaron Klein and Christy Jacobs being open to it, and I would just hate to have some new legislation sort of undermine that progress, or at least you know, make that progress going forward a little uncertain. But I agree, it's a difficult call to make, because the other thing that concerns me is that, you know, much of the legislative effort that Maureen was talking about, for instance, the tribal exempt bonds, is about, or the principle of you know, establishing parity between states and Indian tribal governments. And here we're really calling out some special differences that would apply to Indian tribal governments that states just do not have. And so the question would be, could that possibly undermine the support we would get on the Hill for this? And maybe Maureen has some thoughts about that.
Sorry, I was on mute. I think that we have to, I mean, we are walking a fine line with regard to messaging and making the argument about our need for the general welfare language. And to some extent, what we're doing is we're arguing that the general welfare exclusion applies to tribes as tribal governments, and that we should have deference in the way that we implement it, which I think is 100%, you know, what we should be doing. But I think we also have to be careful about straying too far from what the general welfare doctrine says and making that argument, because at its base, actually all of the arguments that we're making in the tax reform sort of area are that we're governments and we need to be treated like governments. And so I'm afraid that if we push it too far away from what the general welfare doctrine is as it's understood by tax, you know, by the Ways and Means people, by the Senate Finance people, by the IRS, we're in danger of losing, you know, the gains that we've been making on this. So it is a fine balance. I think we do need to be careful how we deal with it. I don't know that I have the answer one way or the other, but I do think it's something that we really need to be cognizant of moving forward and how we fashion the arguments with regard to that.
Right, and this is Lynn, and I agree with the statement that we've made a lot of gains because surely we're in a better place than we were. And I do think that the additions to or the changes that have been made to this draft legislation have been really good changes. And so I think about the one phrase that talks about giving deference to the Indian tribes, and I wonder if maybe if we just put it up on top of, kind of in the general statements before it gets into the specific programs, if that helps us in any way.
Yeah, I think that makes a lot of sense, and we have a couple more comments of folks that feel like the language should be more broad and not specifically call out programs. And I think the fear is, as mentioned earlier, just we might miss something that wouldn't be covered. And then we have another comment that speaks to kind of what Chief Malerba was just talking about, and it comes from Kitke, and he says, how can the deference language be more prominent in this draft? It is really the key to tribal government structures making decisions that it sees best for its communities and citizenship. So I think that was a good question. So I think just how can we underscore the need for deference to tribes a little more than is in this draft?
Yeah, that's a good point, and I think you could probably, it makes sense to move it up and maybe identify it as sort of the governing principle. Instead of just, it's under right now, quote unquote, special rules, but I think it could be moved up sort of the, not maybe just the governing principle or the manner in which the provision is to be interpreted generally, which is, with in favor of the tribes and with deference to the tribes. So maybe it would be sort of an interpretation clause and we just move it up to the top.
Yeah, I mean, to me, it seems like it's similar to the rule about, that it shall not be failed to be treated as a government program solely by reason that it's established by tribal custom. That's kind of a rule of interpretation, that tribal customs are going to be respected. And maybe this is also, a similar rule, that there's going to be deference to tribal government decisions.
I agree with Kiki and Chief Malerba, too, that this needs to be highlighted. And it seems like such a simple concept to us, but having that in this draft, and if it moves forward the way that we want it to, it will be a huge win for us to have that in this type of legislation. So I think that we need to highlight as much as possible, but I think it's a great development as well.
All right.
Thank you, guys. The next question we have is from Chairman Allen. Chairman Allen is raising his hands, which is a great thing for you guys to do. You just have to click on that icon with the hand, and then we can unmute your line and hear your wonderful voices. So right now I'm going to unmute Chairman Allen's line and allow him to ask his question to everyone on the line. Chairman Allen, you are now unmuted.
Thanks, Derek. Didn't know I had a wonderful voice. That's probably debatable, so we won't vote on that one. I guess, listening to the comments and critiques of these different programs and what's eligible, what's not eligible, and how there's some decisions can be made. I just want to make sure that that this draft does the best it can to defer to tribal programs defining tribal programs or policies that define where these programs are identified, the eligibility criteria, and the process of what kind of activities should be included. Because we have said numerous times now that they will vary from tribe to tribe. There will be common threads, but there will be some variances in terms of how they serve their community and address these different topics that are in this current draft. So I think this is really a good start, but I just sort of want to try to help steer the flexibility in deferring to the tribal policies. I can't think of the right word right now. Maybe the codes or policies that guide these exemptions.
Thank you for those comments, Chairman Allen. Would anybody like to respond to that?
This is John. To me, it seems like you could, in the section about deference, which we're already talking about, moving up to a more prominent position, that we would, maybe expand that it would, the deference would not only be to the tribe's determinations of community need, but also to the tribe's codes and procedures. Something along those lines, perhaps.
I think that makes a lot of sense. The next comment we have, and it's sort of a suggestion as well, is perhaps we could have a new section on the implementation issues to address some of the training and oversight concerns tribes have raised. Perhaps some language along these lines. Implementation and training, the Secretary shall establish regional tribal advisory committees to serve as tribal points of contact with IRS field offices and shall advise the Secretary on the training programs, technical assistance services to tribes and other mechanisms to ensure consistent implementation of the Act. B, a National Tribal Advisory Committee made up of the representatives of each of the regional tribal advisory committees shall advise the Secretary on matters of Indian tax. And then another section on education and training. The Secretary shall require training and education of IRS field agents in the field of federal Indian law and the federal government's unique legal treaty and trust relationship with Indian tribes, and training of IRS field agents on collaborative mechanisms for developing training and technical assistance to tribal governments and tribal financial officers to facilitate the implementation of this act.
Well, that all sounds very well thought out, and sounds like something that we should probably add to the text.
Yeah, this is Wendy. I like those suggestions. My only concern would be, would they be considered to be sort of a separate, something separate from the general welfare exclusion, at least in terms of what the House and the Senate are willing to put forward? Would it be two separate bills, or you know, if it's incorporated into the general welfare bill, is it only going to be limited to the general welfare considerations, or do we want it to be broader? Is there some way to push forward this tribal advisory committee that we've all been asking for? You know, do we append it to this, or do we make it separate?
Yeah. That makes sense, because it's you know, that's not only about general welfare. That's about a huge. There's a lot of tax issues, and you know, my thought is that it could be you know, just we have a list of other tax issues. For example, the tax-exempt bonds and the pension issue. You know, we could add it to that list as you know, of other legislation that we'd like to be included.
Yeah.
So the next comment we have several comments from Michael. So what I'm going to do is, Michael, you are on the line, so I'm going to unmute your phone so you can ask your questions directly to the panel. So Michael, you are now unmuted.
Okay, thanks a lot, Derek, and thanks to the panel. I guess maybe I'll start with just a comment that on the implementation of training issues, and I agree that wholeheartedly that the advisory committee should be advising the Secretary of Treasury on the whole range of Indian taxation issues. I guess one of the thoughts is sort of in the general welfare arena, some of the training and oversight issues have been most sort of apparent, and where IRS sort of overzealous evaluations has been, you know, most disconcerting for tribes. So you know, it's kind of encourage us to consider adding language specifically to the general welfare on the implementation of training issues, in addition to sort of a broader advisory committee on other tax issues. But on that, I guess the other comment I had was related to the question of deference to tribal governments and the trust responsibility. I think, you know, Chairman Allen addressed this, Hickey Carroll addressed this, and others. But you know, one sort of thought in terms of there's one area that, you know, John mentioned as deference to tribal codes and procedures. But what about some kind of term addressing sort of deference to the whole concept of promotion of the general welfare in tribal communities? And I think this might be the opportunity to bring in references to federal Indian law, which a number of tribal leaders have commented the need that the IRS needs to move beyond this idea that they can interpret these things just based on federal tax law when you're dealing with the whole concept of the trust responsibility and tribal sovereignty. So one of the thoughts is whether there could be some language on, you know, stating something like along the lines of, you know, whether a tribal program is for the promotion of the general welfare shall be determined based upon applicable tribal and federal laws, and with due consideration to the fiduciary responsibility of the United States to promote tribal economic development, tribal self-sufficiency, and strong tribal government. So that kind of language to get into play there.
Yeah, I like that. One of the things that we did with the advisory committee is we had suggested to the IRS that there be just general, we'd suggested this deference concept, and sort of made the argument that, you know, once the tribe has sort of engaged its legislative process and determined that there's a need, and they've articulated what that need is and how they're going to meet it, that should be it, that there should be deference to that determination process. So it's, you know, it's a broad sort of deference given, and we had at the time sort of proposed it in the form of more like a rebuttable presumption. Once they show that they've had this process, they've identified a need and they've articulated it and clearly identified how they want to meet it, that the burden should shift to the IRS to prove that it's not exempt. And as you can see from the IRS guidance, they didn't go for that. But I think to your point, Michael and Chairman Allen and others, you know, I think if we broaden this deference provision, we might get to where, you know, we want to be or wanted to be with the IRS guidance.
One of the comments we have now comes in from John, and it's basically recommending that the Tribal Advisory Committee language should be included in this draft bill because it relates directly to the implementation of the GWE codification, but also could address IRS targeting of tribal GWE benefits, tribal tax-exempt bonds, etc. And then we also have Kim has raised her hand. So Kim, I am going to unmute your line and you can ask your question directly to the panel. Kim, you are unmuted right now.
Hello. Thank you for that. Just a few points. I think one is they were raised earlier, but just I think the whole notion of this draft of the Nunez, I guess NCAI's draft of the Nunez proposal, is just the danger of perhaps too narrowly defining tribal benefits. You know, given the numerous undefined terms that are used in the draft guidance and the fact that this current draft kind of incorporates all of those areas, I think we run into the same problem. You know, I was going through it and just also walking through the draft comment that was the subject of the last webinar and saw several areas where there is ambiguity in undefined terms, such as, you know, principal residence or what housing assistance is or habitability or utilities or, you know, disabilities. I mean, we've had tribal leaders who have said that they have, you know, their own interpretations of what some of these things mean, and without stronger deference language, particularly, I think, then we run the risk of too narrowly defining this. But in addition to that, just going back to, I think, John Hart's comment earlier, is just, you know, why not, as a threshold matter, start with just making sure that tribally funded programs that are administered and authorized by tribes are excludable from taxation. We start as a threshold matter. Maybe as examples, you know, point to the general welfare guidance, such as housing, education, those things, but be more broader in what that means, because I think that is more respectful of tribal sovereignty and the decisions that they make regarding the welfare of their citizens. I also think rather than have a deference section, the courts are probably more inclined to look at a section called Statutory Construction and probably may lay out specifically what that canon is, which is ambiguity should be resolved in favor of tribes, and then more specifically talk about deference given to tribes and decisions that they make regarding the programs administered and authorized by them. And that would incorporate any decisions that they've made regarding, I guess, the definitions of some of those terms. But those are kind of thoughts that I have, and I think John Hart raised the question, or the point that I had about the need for inclusion in the general welfare portion of the proposals to have training implementation and to have the advisory committee all included in this particular provision. I mean, it's clear that from the discussions that you guys have had with Representative Nunez that he has seen emerge the general welfare proposal as the priority of Indian country, and that has generated at least the most discussion. And so I think that as a result of that, if we're going to get any of those kinds of provisions included, then certainly I think this proposal is one where those provisions should lie. And I think that's about the end of my comments.
Thank you. Hey, Derek, could you scroll up a little bit to kind of the leading part of this? Because I think that's what some of the discussion is about, is right at the beginning. Yeah, there you go. An Indian general welfare benefit, this is the general language, where all programs and all benefits would be included within this general definition of an Indian general welfare benefit. And then the concept, as Wendy laid it out, is that there would be, in addition, some programs would be specified so that as a way of, making sure that we didn't lose any ground made by the IRS guidance. So, we're trying to cover both. The first section is general umbrella that covers everything, and then this second section, or section C, on special rules is trying to cover a broad range of specific programs. Anyway, back to you, Derek.
Okay, our next question comes from Chairman Allen. I will unmute Chairman Allen's line, and he can ask his question directly to the panel. Chairman Allen, you are now on the phone.
Thanks, Derek. You know, I guess a lot of us are trying to figure out how we can be supportive of a bill that is as best described as all-inclusive, or as inclusive as we can get. And then I guess picking up on John's point and then the earlier comment about the deference section, I guess one of the things that I'd want us to explore is this. Well, let me back up, if I might. I do up front. It talks about members, and I really want us, when we go after legislation and we're referring to our people, we refer to them as citizens, because the stature of a citizen versus a member is different in the eyes of Congress. So I think that that's an important thing that we need to incorporate into legislation that we want to support. But going to the main substance is trying to get this piece of legislation to be based on our unique sovereignty and the unique standing of American Indian, Alaskan Native peoples. And I'm not sure that the way the thing starts off does that as well as it could or should. And I'm not trying to overwhelm the legislation to cause a stumbling block, if you will. But you know, the deference section, you know, under that on page 2, I guess, it really is deferring to, you know, our unique standing. And so yeah, I think there needs to be a fundamental foundation point that the legislation recognizes, that empowers that deference authority, because it's really going to the authority of the tribe to establish, as John points out, codes or policies that provide the guidelines for how we you know, compensate or provide assistance, you know, for our citizens for various purposes that should not be taxed. I guess I'll leave it there.
Thank you, Chairman Allen. Would anybody like to respond to that?
Well, sure. I mean, I'll give it a shot. I mean, I think we are going to try to go back and do a bit more drafting on the deference section to move that up into a more prominent spot. And then, you know, maybe if you scroll up to the top a little bit, you know, that section we were just looking at, it may be that we can include more references, you know, to tribal governments and tribal government authority, and within, you know, B1. You know, but I guess I'm not going to try to write it right here on the phone. We'll, you know, we can probably need to go back and do some work on it and see if we can incorporate all these comments.
Hi, this is Lynn. And again, I think, you know, it is a balance, and I think tribal leadership really needs to think about, you know, risk-reward in terms of strategy here. And, you know, we don't want to lose the areas that the IRS has already recognized, but we definitely want some flexibility there. So I agree with all of the commenters in terms of trying to kind of strengthen that, you know, the preamble, so to speak, because remember, everyone who's reading this legislation has a different understanding about Indian country, Indian law, and tribes as sovereigns. So I think, you know, we definitely need to strengthen that. And, you know, and I think about, as I said, some of the programs that even I did, when you think about elder services, one of the things that we provide to our elders is snow plowing, because we don't want them out in their driveways shoveling in the middle of the winter. And so I think everyone has some unique challenges. So we want to make sure that we protect what we've already had, And I think we just need to think about what kind of flexibility or what kind of language that we can insert that will give us some flexibility in other programs that perhaps aren't specifically mentioned. So maybe we just need to think about crafting some language and then going back out to tribal leaders to see what they think about that.
I think that sounds like a great approach, Chief Malerba. Thank you for those thoughts. We have a couple of technical suggestions. Kim suggests that we change the language under specified guidelines, and I believe she's speaking to the number 1 right there on your screen, and she says, how about changing the provision to the program is administered or authorized by the governing body of the tribe and does not discriminate, etc. So I think that's a good suggestion, Kim. And she also noted that in our draft joint comments, we included extracurricular activities under educational benefits, but that they are omitted in this draft language. So just keeping us on our toes there. And then we have a general question of whether or not the red line, which we're considering, will continue to include the specific programs, or whether or not we'll consider going more broad with no programs, but more just the framework for the general welfare exclusion.
Well, this is John. I mean, there seems to be 2 points of view here. You know, one point of view is to have it very broad and then also list some specific programs. And then the other view is to not list specific programs at all and just have the broad definition. And you know, I don't know that we can resolve that here on the phone. Our thought was to try to do both, you know, not one or the other, but to include very broad language and some specific language. But, you know, I suppose at some point tribal leadership will have to resolve that question.
And on that note, we have a tribal leader in the queue. So I will ask Chairman Allen to respond to that. Chairman Allen, you are unmuted.
Okay, thanks. Yeah, I want to pick up on a couple of points. John's last point is I think it's well taken that we really need to deliberate on what we are advocating, because if we don't get somewhat specific in terms of identifying programs or categories of programs that are exempt, you leave it to the discretion of the IRS and agents. And that I see problems in that venue, and inconsistencies or variances of how they interpret what will fall under these different guidelines, or if they find themselves having a variances of guidelines across the nation, trying to create a consistency from their perspective, which can cause a wrestling match between the tribes and the IRS and their agents. So there's that issue. I also wanted to ask the question about when I'm looking at the first section on the general welfare, 1 and 2, and the subsections underneath it. I guess I'm not quite clear how this would apply. If we have programs that are targeted at elders that we feel should qualify, or programs that are targeted at single parents, we're trying to get educated, well, then will somebody try to say that's a discrimination against them versus someone else who would want that service, when we are very specifically targeting a sector of our community that is in need. And so, and then the last one under D, under 2, the not compensation for services. And this is just an open question that we're going to have to wrestle with, because if an agent comes in and says, well, that's not compensation for a service that or something that is needed by the community or an individual in the community, that's really a service. the question will be how that determination would be made, or even how it could be resolved, so that it doesn't become problematic for the tribe relative to that assistance or that issue that is being compensated.
So this is Wendy. I can address, I think, take a shot at both those questions. In terms of, programs for a particular class or group of individuals, the discrimination restriction is only as it relates to members of the governing body of the tribe. And then subsection 2A, where it says it's available to any individual who meets such guidelines. Then, for instance, your elder programs would say for persons over 55 or whatever, or you would identify how a person would qualify, and it presumes that there will be certain groups or classes of people who will qualify for different types of programs, so it wouldn't be considered discriminatory. And I think that was explained in the guidance, IRS guidance as well. And this follows that same terminology that the IRS used in their guidance. And then in compensation for services, well, we still retained under Section 3 the ceremonial activities, payments not being treated as compensation. But then just broader, there will be situations where when you think about perhaps a tribal government official who's on the payroll but also is a recipient of certain benefits. I think the way, at least in my experience, the IRS would work that out is, if the payment looks to be connected more with the service as opposed to the program, then that's where the problem comes in. So I think it would be fairly easy for any tribal government to establish that if they have these program guidelines and that they're following them, then there would be no question that it would be an exempt payment and it's not related to services because it's you're following the guidelines. It would only be if you're making payments probably outside the guidelines that appear to be connected more with services provided. But to date, I haven't really seen that issue come up too much, at least in my experience. Others on the call may have had more problems in sort of making that distinction or drawing the line there between services and exempt benefits.
Thank you, Wendy. Next, we have a suggestion that we include something similar to what we included in the joint comments that we reviewed last week, and they're referring to the section that included an exemption for programs established by tribes that are intended to supplement or make up for federal programs that are underfunded. And I think that's a good suggestion. And we also have Kathleen in the queue. Kathleen has her hand raised, so I will unmute Kathleen's line. Kathleen, you are unmuted and can speak directly to the panel.
Thank you, Derek. And thanks to all who took the laboring oar on this draft. I think it's excellent. I think it really covers the waterfront. One thing I'd like us to reflect on, and this goes along with, I think, in some ways what John Hart is trying to get at. We don't want to narrow the general welfare doctrine generally too narrowly, because after all, when we look back at it, I mean, the general welfare doctrine really only has 3 requirements: that it be a program of a government, an Indian tribal government in this case, that it be for the promotion of the general welfare, which the IRS has defined as based on individual or family need, and we're proposing here be extended to community need. And then the 3rd requirement is that it not be compensation for services. So looking at the first section, maybe what we should do is just have those 3 requirements, and then like the approach in the IRS notice, the additional requirements like that there be eligibility guidelines, that it not be lavish or extravagant, and non-discriminatory, et cetera, that those additional requirements be linked with the special rules, because the special rules basically, they create a presumption that the listed programs are on the are presumed to meet an individual, family, or community need, or that they would automatically meet the second requirement. And those could, if those are included at all, it seems like those should be included as part of the special rules, so that tribes who have general welfare benefit programs that are on the basis of need, they wouldn't automatically have to have eligibility guidelines if indeed they really were meeting the general welfare doctrine as it was. What are people's thoughts on that? I'd be interested in any other comments.
Would anybody on the panel like to respond to Kathleen?
Yeah, this is Wendy. I like that idea. I'm just looking at this now, trying to figure out exactly how to accomplish that. But yeah, so what we'd be doing is really the current draft or iteration just sort of parrots the IRS guidance. So you're saying we would tease that apart a little bit and make the broad general welfare, make general welfare exclusion a broader definition, and then add the additional requirements as special rules if under a subsection C, a new subsection C. Is that what you're saying, Kathleen?
I mean, even the notice actually does recognize the fact that the general welfare doctrine still basically only has 3 very broad requirements.
I like that idea, Kathleen, of kind of separating it out so that you're identifying the actual 3 provisions of the general welfare doctrine itself, and then teasing out those other ones and putting it like in a special rules section. I also wanted to say I liked Kim's idea of having a statutory construction instead of deference. I agree with her that sounds stronger and would get more deference overall if that's how it was worded.
We also, as a follow-up, have a clarification. So one of the attendees wants to know whether or not Kathleen is suggesting to take out the quote-unquote safe harbors to make it more broad. Kathleen,
no,
you're still unmuted,
no,
so you can respond.
Yeah. Okay. Yeah, I wouldn't be suggesting to take out the safe harbors, and here's why. I'm thinking about this in terms of, as a legislative vehicle, if you don't have specificity in your bill, it's going to be scored as a huge number. We have some hope, I believe, of having it have a close to neutral score to the extent that we're going beyond what is already in the IRS guidance only incrementally, and we're codifying that. But if we basically had an open-ended, provision that said that a tribal government could basically define the benefits however it wanted to, and it would all be excludable from income, I think the reaction to that from joint tax would be to give us a very large number, and that would really lessen the chances of getting it enacted in the current climate.
Okay, thank you. Any other thoughts on that?
I guess this is John. My only thought is that I think to some degree it's getting posed as, as like, do we go broad or do we go narrow? And I don't think we want to do either one of those. We're trying to do both. And I liked, Lynn's suggestion that one way to make that very clear would be to include language that references other programs that are not listed. And we'll have to come up with some language to do that. But that might help make it really clear that there's both a broad exclusion for all general welfare programs, and then also a specific list to just to be sure that one doesn't cancel out the other.
This is Lynn. So I agree. I think we need to just think about language that kind of tries to, and I agree with you, John, we need to do both. You know, because we need to make sure that we protect what we've already gained, but we don't want to lock ourselves in so that there are programs that we may choose to provide to our communities in the future, or that we provide right now that we just didn't think about. I don't think you ever want to just go with one laundry list and say, okay, now we're done. Because as we all know, if we do get legislation passed, it's unlikely that we will be able to then get a redo. Or a do-over on that. So maybe what we can do would be to propose some language and send it around to tribal leadership and see what they think.
Yeah, we'll get drafting on that. And there's a lot of smart lawyers on the call with good ideas for helping us draft this.
Absolutely.
Well, it kind of seems like we're at the end of our questions, guys. So does anybody have any closing thoughts?
The only closing thought I would ask is that a number of you have made very good suggestions, and if you have ideas for how they should be written out, please send those to us so that we can incorporate them. You know, we took notes, but we don't always get it exactly the way that you might have better ideas. So you probably have Derek's email address and mine, and we'd be glad to receive any written ideas on how to improve this.
Yeah, and I would just say thank you to everyone on the call. I think the discussion was really helpful, and and I think we have a good sense of where people want to head with this.
Sounds good. Chairman Allen, would you like to offer any final thoughts?
Well, the only thing I want to add is just to chime in on Lynn's comments. You know, this is a very important opportunity for us, and I think that we need to get to the point where we clearly have leadership both in the Senate and the House, and they're on board. Our end product is not going to be the perfect product. We always got to keep remembering that. But it's a whole lot better than our current situation and conditions that we're wrestling with. So I think we try to do the best we possibly can, and basically eventually run with that, and not be disappointed that we overlooked something that sure as shooting will show up. But we gotta give it our best shot, because the conditions are right now. And may not resurface again for many years to come. So meanwhile, this is clearly a fabulous opportunity for us. And I'm like Lynn and Kiki. I really appreciate the leadership that jumps on board, and the legal expertise that represents numerous tribes across the nation. You guys, your advice and counsel is outstanding. I deeply appreciate it.
Okay, well, it seems like we're out of questions. If there's not any other final thoughts, I just want to say I appreciate everybody registering and logging on for this webinar. I think a lot of us are very excited about these new technological tools that we're using. So we thank you for your participation, and we'll post this online. We're recording it, and we will send out slides and the draft language as well. And as John said, email myself or him with any suggestions, and we'll be following up with you.
Okay, thanks, everyone.
Thank you.
Thank you, everyone.
Thank you.